It's a very good day today. We are starting episode 6 with Conrad Atiang, coordinator Kituo cha Sheria hapa Mombasa, but is the regional coordinator, though the office that is managing is in Mombasa County. Today we are going to focus on the small claim court. I think majority have heard about this, but do you know its obligation? Do you know what it does? Do you know the cases that is supposed to be heard in that court? Do you know how one can file a case in that court? Do you need a lawyer actually? Do you need an advocate of the High Court for you to file a petition or a case? And do you know why it was brought by the Chief Justice? I think now it is 5 years old.
It's about 5 years.
5 years old, sindio?
Yeah.
So wakili yuko hapa, Conrad Atiang, atatupatia maelezo mazuri kuhusu the small claim court. My interest is about the new amendment bill. Remember there was a bill, amendment of 2016 if I'm not wrong, and then there's another one of 2025,
Yes.
if I am not wrong. So I will wish to know, why do we amend here and there? Wakili, karibu sana.
Asante sana.
Yes.
Thank you so much for having me.
Yes.
I've been looking forward to this conversation for quite some time now.
Yes.
And it is quite timely that you have invited me to your podcast.
Yes.
May I commend you? You are doing a good job with this podcast.
Asante.
Thank you.
Karibu. So tumeingia na tunataka tu kwanza tufahamu
Yes.
mahakama ya madai madogo madogo.
Yes.
Mahakama ambayo imekuja katika safi ya shughuli ya kutafuta haki kwa maana ya access to justice. Ukiangalia katiba yetu kipengele 48 inazungumzia access to justice.
True.
Pengine kwa maelezo, mahakama hii imejiri kwa manufaa gani?
Mahakama ya madai madogo madogo imekuja kwa minajili ya kusaidia mwananchi wa chini zaidi. Na kusudi ya mahakama ya Small Claims Court ilikuwa ni kujaribu kutatua shida za kifedha ambazo Mkenya wa kawaida anapitia ili kupata haki yake ya kifedha. Kwa mfano, hiyo ni shida ya deni ama maagano moja ama nyingine, ambayo mara nyingi inakuwa ni lazima mtu awasilishe ombi mahakamani ili apate haki yake. Kwa hivyo sheria ilibuniwa kwa kusudi ya kurahisisha hiyo safari ya kuingia mahakamani na kupata haki. Kwa hivyo, kwa mfano, mbeleni lazima ili upate madai yako ya kifedha lazima ungewasilisha kwa Magistrates Court, Chief Magistrates Court.
Yes.
Ikawa ina hitilafu za muda wa kusikizwa kwa sababu ya kalenda ile refu ambayo Magistrates Court iko nayo.
Ndio.
Ikawa iko na mawakili ambao mara nyingi watu walihisi kwamba pia wanachangia katika kurefusha muda wa kusuluhisha haya madai.
Ndio.
Ikawa iko na mambo ya mashahidi kuja kotini. Sasa hii sheria iliyobuniwa ya Small Claims Court Act ilikuwa na sehemu fulani ambavyo vilikuwa vinaondoa zile tunaita pitfalls, zile changamoto ambazo zilikuwa zinarefusha safari ya kupata haki.
Ndio.
Na pia ikawa inasema si lazima uwasilishe ombi kupitia kwa wakili. Pia ilikuwa inasema si lazima tuzingatie pia sheria ya kiprocedure sana.
Ndio.
Jinsi ilivyofanywa katika Civil Procedure Act.
Ndio.
Ya kwamba Small Claims Court pia inaruhusisha tu isikizwe tu kwa njia ya kawaida iwezekanavyo. Kwa hivyo haya ndio yalikuwa nafikiri ilikuwa ndio msingi zaidi ya kubuni sheria ya Small Claims Court Act. Na ilibuniwa kitambo tukiwa na Chief Justice Maraga. Naam. Na tukawa sasa baada ya hapo ndio huyu Chief Justice Martha Koome akafanya sasa kuipa nguvu, kuipa wafanyikazi kupitia kwa wale ambao tunaita adjudicator na staff. Naam.
Yes. So the main purpose of small claim court was just for the business purpose, eh?
Yeah.
If perhaps I have somebody is owing me you money,
Yes.
and maybe there's a difficulty for that person to return the debt.
Yes.
And now taking it to the magistrate court could also have some limitation in terms of accessing the justice because of the processes and the backlogs in the court.
Yes.
So small claims court just come in to ensure that the process is shortened.
Yes.
And also you don't need an advocate of the High Court.
Exactly.
So even the fees to access that justice is also reduced. And perhaps if you've said that you don't need an advocate to access that, and you said also the access can also be done online, and maybe there's a layman person, these people sometimes they didn't get the opportunity to understand the law, they are not familiar with the corridors of justice.
Exactly.
Maybe he has 1, 2, 3, somebody alipeana mtu 1,000 amekataa kumregeshea, either it was 1 million amekataa kumregeshea. So can you take us through the process before you tell us how much can we secure through this legal process in this small claim court? So how does one start the procedure of getting justice in a small claim court?
I will start by the answer to the question, how much can we secure? The court limits the amount of money that is supposed to be sought after from the court to 1 million. But in the event you have a claim that is above 1 million, then the court still allows you to claim, but only up to the 1 million. So that there's a waiver clause in the pleadings that you present before the magistrate's court that says that you have agreed to forfeit the surplus of 1 million. So if your claim was 1.4 million, and then you have decided to go to the small claims court because of the advantages that are obvious we are talking about, then the understanding of the court is you have actually accepted to waive up to the 1 million. But now, even in the new amendments, the discussions we are having is that then the regulations especially, that the 1 million mark is on the actual claim, but it is not on what the court may award. Because remember, at the moment we are talking about amendments, which we are going to, I believe we are going to discuss later.
Absolutely.
Is that then the court may award costs and other consequential, costs that are now going to be slightly above 1 million. But what the jurisdiction of the court initially was you can only be able to recover up to 1 million from that court.
So can I do it partially? I say now let's focus with 600 and then we come for 800.
It would be a bit difficult to succeed in that manner, because the law, the way it is created is once you present a cause of action over the same subject matter on against one party, then the court will stop you from presenting a similar action in future over the same subject matter. I would advise that if you want to present a cause for 1.2, for instance, and you want to present it in bids, in installments, you will not succeed because of a principle of law called res judicata, the principle that prohibits you from presenting this action for the second time for determination, so that you can only present it once. So you choose either to present 1.1 million and waive the 200,000, or you present the full 1.2 million, but in the magistrate's court.
The magistrate's court. So the Gen Z idea of I can now go for small claim court in Mombasa, file a case up to 1 million, then you need to Kana. And file for my 200. It can't work.
It will not work. Because you sue the same person, and the same person will come back and say, I have already been sued in Mombasa for 1 million over this transaction. So I cannot be sued for another 200 over the same transaction. The easiest thing would have been, and I'm happy with the new amendments in the proposed amendments in the Small Claims Court Act, that allows the Small Claims Court in Mombasa to transfer the matter now to Turkana so that they are heard together. But the disadvantage of that is now being transferred to Turkana for hearing together will mean this claimant must automatically leave out the 200,000.
So what is the process, the procedure of filing?
The procedure of filing...
Talk about it as you consider the layman perspective.
The procedure of filing is fairly simple. Is that the number of documents that have been availed for presentation of a claim in the court has substantially reduced, in the sense that the statement of claim before the small claims court is in a standard form. In fact, in my view, it does not exceed 2 pages. Secondly, is that it can be hand-filled by the person claiming, just detailing the person they're claiming from, their address or their presumed address, their phone number if they know, and then they can list down the details of their claim, including the cause of action from which that claim arises. And then they do a small statement and the amount they are claiming. That form is available online on the internet.
Yes.
It is also available in our court registries, both the small claims court registries and even the magistrate court registries.
Yes.
So once you have that form, then you can fill it and then you can file it. You are also expected to also file a small brief statement of how your claim arose, and then you can also file just your bundle of documents. And like I said earlier, David, is that the strict rules of procedure as they are in the civil courts, both at the magistracy level and the subordinate and the high court level, has been relaxed in the small claims court, so that even if you just loosely, let me use the word, throw your documents on the portal, then it will still be admitted as though you have properly filed them. But in order for someone to file, then the first step is that a particular lay person who has a claim ought to have an existing portal on the judiciary online platform system, where now he can or she can lodge the claim from that portal and become a member of that portal. So once you have your portal login credentials, and these days, in the year before last year, 2024, the judiciary went out to train some cyber cafes in major towns and cities on how to introduce people into the small claims court.
Wow.
They also trained Huduma Center staff on how to engage with the judiciary on the case tracking system. So the information on how to log in and establish your account on the judiciary system is out here in the general public, and most people do not even know that you could actually walk into a cyber cafe and someone will help you establish an account. So once you have that account, you can operate it from the phone. You can operate it from your laptop in the house or from a desktop computer. Then you can proceed and file.
Okay.
Yeah.
Why did the court, in its wisdom, sees that there is no need of having an advocate for filing such cases?
Yeah.
Why?
The idea was not that they do not need advocates. And being one of the advocates, I must also come out quite strongly to defend our colleagues, that the idea was to reduce the cost of litigation to a lay person. Advocates and legal service is not a cheap service. So that I will charge as according to the scope of work. Sometimes the scope of work, the cost of the scope of work that I am rendering could be higher than the value I am trying to recover. So the idea was not to lock out advocates. I will tell you for free that there are some that have an idea of how the portal works, know the process of filing these claims, but still opt for an advocate to do this work for them. There are advocates who will also tell you that I had a paying client, comfortably paying client, prior to the enactment of the Small Claims Court Act. Now, are you going to ask this client of mine who has been with me for the last 10 years to stay away from me because the Act now says that they can self-represent? I think that the idea was not that, to lock out advocates. The idea was that you owe someone 10,000, someone owes you 10,000 shillings. What would be the ordinary cost of recovering 10,000 shillings. Now, if you go the advocate way, and advocates are prohibited by the law from something called undercutting, which means to charge lesser than what is provided for under the advocate's remuneration order. So that if this advocate is going to then ask you to allow him to first do a demand letter for this 10,000 shillings, some advocates will charge you that 10,000 shillings for that demand letter. So the idea was to reduce the cost of recovering the money and not to lock out advocates. If the client is comfortable to pay 10,000 for this demand letter, then I believe there should be no problem for this person to continue being represented. Remember, in the court, again, there's a provision for recovery of costs of the suit. And now we are actually, in the process of amendment, we are actually now re-engaging on how much then should be proper costs before the small claims court, so that we also accommodate our colleague advocates in this process.
You know, in my understanding, I thought maybe advocates have seen that there are so many criminal cases that this small claim court cannot make their client's account dormant.
That there are so many
criminal cases.
Yes, that makes
that the small claim court cannot make their client's account dormant.
No, that was not the idea. In fact, I think that those that have embraced the small claims court, despite the little fees or costs that come from that court, are actually very comfortable in practice. And I'll tell you that between 2022 and January this year, the small claims court was handling personal injury claims, accident claims.
For sure.
For a very long time, for about 4 years. And then this meant that most of what we call mainstream practice of litigation, something we call running down in our practice, was under the small claims court. This actually is the reason for which we are now seeing a new process of amendment, because a court in Eldoret in January made a decision that these are matters that ought not to fall before the small claims court. But so you cannot say then that an advocate was just okay with not appearing before that court, because for a long time many of our colleagues were in that court.
So this question, I think it is not out of context in this sense. Can small claim court embrace the AJS system, the alternative justice system? Let's say somebody, me and candidate X, have a problem with 1 million. One owes the other. And then now we say the person who is claiming the money has go and lodged a case, and now the process is underway. Then the candidate X saying, no, it is true that this person I should pay him 1 million, but I can't afford it. So we can discuss this outside court, so that I don't wait for that judgment, because maybe the verdict can also interfere with my process of paying that amount.
In fact, in most circumstances, it's like that. I really must laud the court countrywide, in the sense that most respondents in small claims actually admit, either on the first or the second mention of these matters, that they actually owe the money. And the only request they usually have to court is, I need to be given this amount of time to be able to pay back this amount of money. And in most circumstances, the court will give them, say, a week or two to go and come back with a solid modality of payment of that debt. So in most circumstances, I think that AJS has been strongly, if we are to call that AJS, has been strongly embraced by the court, in the sense that it gives room for parties to agree on actually the mode of payment and the amount of time required for payment. But let's look at it also in the reality side of it, that by the time someone makes a decision to go to the small claims court, possibly they have taken this respondent up to the police station, it has failed. They have tried to collect this debt in almost all manner of ways available before you approach the court. So as at the time this person is coming to propose to pay, maybe by installments by 5th of each month, then the trust between the claimant and the respondent had been breached a long time ago, and it becomes easy for the parties now to actually come to an agreement, because what they will say is, he has been promising that way since 2023. So if he is still coming back to lie to court that he will be paying me by 5th of every month, then I'm not okay with that. So the rigidity comes out of the lost trust between the parties. Yeah.
But there is no limitation for alternative justice.
There is no limitation at all.
Oh, okay. So we can just make a formal agreement, then we present it to court. We say we have agreed. I owe him this much. I'm going to pay through this procedure.
Absolutely.
Oh, that is good. So another thing, perhaps, when we're discussing the small claim court,
yes,
the people who seems to be the most or the beneficiaries are the small, the SMEs,
yes,
the small traders,
wafanyabiashara
wadogo wadogo,
yes,
in most cases. So maybe, do you have the knowledge of how many have been helped through this system?
In Mombasa or countrywide?
Yeah, no, in Mombasa.
In Mombasa, the numbers come to about 700,000.
So almost 0.7 million people,
yes,
have accessed justice.
Have accessed justice through the small claims court, but we have to give it a timeline.
Yes.
Yeah. If we say 700,000 blankly, we might not really assist.
Yeah.
But by about February of 2025,
yes,
we were looking at 700,000 to 1 million people just accessing justice through the small claims court. But I want to say that the impact nationally could be substantially bigger than what we have in Mombasa since its establishment in Kenya. For example, the small claims court has been able to determine over 50,000 cases since its inception, I think between 2021 and 2022, up to now. That translates to about 9.3 million Kenya shillings up to February of last year, which means if you add what we have achieved after last year, March to this year, which is coming to about a year, we are talking about 12 to 13 billion Kenya shillings. So the impact in terms of just reaching, seeing, because you see the essence of the court was to completely resolve the backlog problem that we had.
Yes, yes, yes.
And by that, we have a court that has a statutory timeline of 60 days.
Yes.
Then that makes things move quite fast. Yeah.
I think that is very good. So, because of time, we want to discuss the Amendment Bill of 2025.
Yeah.
If I'm not wrong.
Yes.
You will correct me. I will stand guided.
Yes.
In the proposal, you started by saying that in the new proposal, now there's a proposal of let's now agree that a small claim court in Mombasa can refer a matter to a small claim court in Nanyuki or Nairobi,
yes,
or in other. Perhaps how will this now make this access to justice be possible? And maybe because now, I think one thing that we didn't tell the audience is that the cases will only take up to 60 days for the matter to be resolved. And there is also another proposal that I think this 60 days is also a small days in the justice system, because there are so many cases too, and there's a lot to be discussed, the evidence things, and so many which are still in the amendment, the proposal in this amendment.
Yeah.
So how would this referrals or referring a case from Mombasa to Nanyuki help to shorten or make sure that this process is going to give an impact in a common mwananchi's perspective?
Okay, you are just discussing the referral bit.
Yes.
Yeah, but there are many amendments.
Yes,
but
yes, yes.
No,
we are going to
go to the others.
Yes, yes, yes.
In terms of the referral, we normally say that that the legislature does not waste words. Parliament, in
Yes.
enacting laws,
Yes.
every single word that is in the statute
Yes.
is normally intended for a purpose. And that's why we are collecting views of Kenyans to see what should be in that act. And the idea of transfer comes in two folds. The first one
Yes.
is that a high court is given, through these amendment proposals,
Yes.
has the jurisdiction to transfer a matter from a high court civil division or a magistrate civil division to a small claims court. You know, courts are in divisions,
Yes.
so that we have small claims court, then we have magistrates court civil,
Civil.
then we have magistrate court criminal, then we have high court, which now has many divisions.
Divisions, yes.
Sometimes it has criminal division, civil division. In Mombasa here we have commercial and admiralty division. Then we have family division. Then we have constitutional and human rights division.
Yes.
Then we also have land and environment court, and we have the employment and labor relations court, which are courts of equal status to the high court. So the high court now,
Yes.
the high court is the one now that is vested with jurisdiction under these amendment proposals to transfer a matter from the high court that ought to have been in the small claims court to the small claims court, or a matter that was in the magistrates court but ought to have been in the small claims court to the small claims court. Okay. The new amendments also empower the magistrates court,
Yes.
not the magistrate, but the small claims court itself, to transfer a matter to the small claims court, to another small claims court. The idea is that if the cause of action arose in Mombasa,
Yes.
and one of the parties, because he is in Nairobi, opts to file in Nairobi, then the party that feels the matter ought to have been filed in Mombasa can apply to the small claims court in Nairobi and say, but this matter was, the cause of action is in Mombasa, and all the parties, including this person who has claimed, lives and works in Mombasa.
Yes.
It is easier for it to be heard and determined in Mombasa. So then the court can then transfer it. The small claims court itself can transfer it to Mombasa Small Claims Court.
Wow.
If this person filed the matter in Milimani Commercial Chief Magistrates Court as a commercial claim, but it is under 1 million, and the parties believe that it can be heard and determined in Mombasa, then again they can approach the High Court in Nairobi to transfer the magistrate's matter in the Chief Magistrates Court in Milimani Commercial to Mombasa Small Claims Court. So that was the whole idea about this transfer. In my view,
Yes.
And this is what I actually submitted to the standing committee on the amendments of that act, that I feel that giving the small claims court powers to transfer its own matters, then once you give the power to the High Court, then the power should remain with the High Court, so that we just let the small claims court, the idea of transfer to come from above and not from between equals. That means like the adjudicators. Because the concern would be if you file a matter in a court without jurisdiction, then the other court can say if they didn't have jurisdiction to hear the matter, then they also didn't have jurisdiction to transfer the matter. And in the inverse, reject the matter. So to avoid that, then let the order for transfer only emanate from
the High Court level.
But it is still under discussion. I believe that.
So just presented the submission were the views from your side as also a legal practitioner.
Yes.
But allow me to put it to this context. Let's say, for example, the transfer of these matters. I'm thinking, I'm not an advocate.
Yes.
I'm just thinking like a Kenyan. Maybe I lodged a case in a magistrate or in a high court before the introduction of this small claim court. And now the matter has taken more than 4 or 5 years. And maybe by the time I was processing my case or I was lodging the case in the magistrate court, I did not have knowledge of a small claim court. So through this new amendment, I can now go to the High Court and request that my matter to be transferred to the small claim court for me also to enjoy the 60 days prime time for my case to be
determined.
So
Yeah.
that is now the case.
Yes.
Okay.
You can, yes.
Okay. So your problem is that why should the small claim court have this authority or this power also to transfer the matter to another small claim court in Turkana? Let's wait for the views if Parliament is going to have it. Another amendment in this, which I hold it dear, was about the evidence thing.
Yes.
Yeah. So take us through about that.
The new amendment on evidence says that all evidence will be, number one, will be on oath, the testamentary evidence.
Yes.
And the other one, which has been there before, is that you can present your matter by way of documentary evidence alone. Now, the contest we have with the new amendments is that it, on one side, says that all testamentary evidence shall be on oath. But when we present the claim, the nature of the claims we present before the small claims court are that under Section 30 of the Small Claims Court Act, that you can just admit the documentary evidence, and then the court will determine the matter based on the documents presented by both parties. Now, Section 30 as it currently is then does away with oral testimonies of witnesses, which ordinarily the new amendment says ought to be under oath. So that is now where the actual disconnection for me is, because on one side you are saying that we have allowed you without any testimony to just present the evidence as it is on documents. But on the other one, it is now giving a mandatory provision that such evidence shall also be presented on oath. A bit conflicting. But the main point which I want you to take home and your viewers is that we did away with the strict rules of evidence,
which was
where you insist on, a document must be produced by its maker. The maker must come and testify. Someone cannot testify on behalf of the other. Quite some strict rules of evidence that we have in other practices before the magistrate's court, before the high court, where evidence must be strictly proven. The small claims a little bit relaxed it, so that if you have documents alone, then such documents can be used to make that determination.
There was a joke that if perhaps I was owing someone 1,000, and then this person does not have any evidence about me and him we lent each other 1,000. So you can take a phone and call me and record that. David, when are you going to pay me my 2,000? Then say, I recorded 1,000. So that can be taken as an evidence.
Very good, very clever. Very clever way of collecting evidence. But yes, I agree that some of those tactics work.
Yes,
you can send someone a text. And then that admission then constitutes part of your evidence. Yeah, I don't advocate for people to start doing that, but I'm just saying that it's a very clever way sometimes people use to collect evidence.
Yes.
Yeah.
So the problem is now all the oral evidence must be done under the oath now.
Yes.
But again, if this thing happens online, swear wapi?
People are sworn online. All online proceedings have swearing.
Nimeapa ya kwamba.
Yes, in the camera, in the small
booth
square of your camera.
Yes.
Whether it's from a phone or from a laptop, people swear. Advocates, as we swear witnesses in our chambers, the court can also swear your witness who is in your chambers. So oath will happen. Oaths happen every day.
That is perfect.
Yes.
There's also another amendment about giving the power to the small claim court to arrest.
Yes, this is a very controversial issue, David. And it is controversial in the sense that when we had the old, let me just call it, it's still the current act, the provision for for execution of decrees of the Small Claims Court fell under Section 37 of the Small Claims Court. And it says that under Section 37, execution shall be in accordance with the Act. Section 39, which I'm talking before the proposed amendments, Section 39 was saying...
So this discussion based on the current Act?
What we have,
yes,
before it is amended.
Yes,
and
yes.
Right now, today, when we are doing this podcast, it has not been amended.
Okay.
I believe people will watch this podcast even beyond the amendments.
Yes.
We are speaking before the amendments of the Small Claims Court Act.
Yes.
Now, the position is that under Section 39, execution of decrees involves attachment of property, attachment of salary, but does not include arrest and detention or committal to civil jail as a way of execution of decree after judgment has been entered. It does not. The introduction of arrest and detention of a judgment debtor after judgment has been entered is introduced by Section 51, which empowers the Chief Justice to create regulations. Now, I think it's in Regulation 25 of now the regulations of the Small Claims Court that are created under Section 51 of the Small Claims Court Act, then provides that you can arrest and detain, commit to civil jail, which is actually, in fact, it just referred to it as execution shall follow what the civil procedure provides. Under Section 38 of the civil procedure, the sanction of arrest and committal to civil jail is there. So that reference is what the Small Claims Court had been using to commit people to civil jail. But the Act itself did not specifically or expressly provide for arrest and committal to civil jail as a consequence of a judgment debt. Now, some gentlemen went to the High Court in Eldoret contesting that the absence of that express provision means that the Small Claims Court cannot now arrest and commit to civil jail.
Yes.
And the court agreed with them.
And it became a verdict.
So
and
from January of 20, it's now a law made by the court. So from January of 2020, I think 26, there has been no arrest and committal to civil jail. Now, that makes it quite a dangerous enterprise in the sense that we are going to actually collect, sue people, but in the instance where this person is adamant on paying, then there's nothing absolutely you can do to them if you cannot find their asset or if they do not have a salary. And in this case, we are dealing with business people who most assets they have are not in their names. And secondly, they do not have salaries. So if those two are the only available avenues under the Act as it is currently, then it becomes quite difficult to say that I'm actually going to fully recover. So the amendment is to now expressly enact the provision of arrest and committal to civil jail as a consequence of a judgment debt, which is quite welcome by most people. Everyone, literally.
I'm not understanding in this context. So when we put this amendment, maybe we add that clause in the new amendment. How will it happen to the verdict that was made by the High Court?
It doesn't affect...
Automatically, that verdict will be rendered lawless?
No, it doesn't affect the verdict because the verdict seemed to indirectly propose the amendment. Because the judge says that the judges say that we have looked at the provision. We have looked at the intention of Parliament. It did not expressly say that you should arrest and commit. So arresting and committing is actually going above what the law says. And so you arresting without a specific order of the law then makes arrest and detention illegal. But if you look at all the other courts, they allow for arrest and detention as a committal to civil jail as a consequence of judgment.
Yes.
Execution. So we only needed to align it with the small claims court.
Okay.
So it just needed one small amendment. So it doesn't affect the judgment at all.
Okay.
Yes.
You spoke about something very important, specifically for that context of if now the small claim court does not have the jurisdiction of arresting, I think now even getting these people, can I call them a culprit?
Yes, you can call them culprits.
To submit
Yeah.
to the kwa uamuzi ambao umefanywa na mahakama,
Yes.
itakuwa ni ngumu.
Inakuwa ngumu.
But now let's take a look at now this scenario that I heard you having this discussion somewhere
Yes.
about nowadays. There are a lot of things that people can buy in installment.
Yeah.
Through the hire purchase. I remember hire purchase when I was doing business studies.
Yes.
Or mathematics. But now you see, if I want to buy a motorbike, I can just go to company X and put at least 30,000, then pay deposit, then start paying by the installment.
Yes.
But you realize by the time I'm done with the payment, maybe I'll pay 3 times or 4 times the actual price of a commodity.
Yeah.
But in some instance, you'll see, if I have paid even, I'm only left with 1,000, then maybe I refuse to pay or anything happens. Now, the company X will come and take back their commodity, leaving me without anything. So can the small claim court come into rescue for these people who have this similar problem?
Yeah, the court can,
Yes.
if you sue the person for the money that you feel is in excess. But the main challenge that we must first address is that is for me where Kenyans feel the greatest pinch is their understanding of the terms of this hire purchase, because I believe most of them are hire purchase. If it is a car, it affects Uber drivers, people who take facilities either with the car yard, or with a bank. Banks are not big culprits for this, but say for instance car yards, or people who are, for example here in Mombasa, people who are in tuk-tuk business and border business.
Yeah.
And the general rule in hire purchase is that the property in the whatever asset you are acquiring transfers to you after payment of at least 75%. Throughout this entire period before this property transfers, they have the liberty to repossess it upon any default. Now, my problem with the society is their lack of understanding of the law of hire purchase and contracts generally.
Yes.
That they think that even if you have paid 50 or 40 or 30 or even 60%, then it is not possible for you to lose an asset. And that's the first omission.
Yes.
The second omission is our people not understanding the how interest rates work, how interests for that particular asset accrues, and how penalties also are levied.
Yeah.
What happens with Kenyans is the excitement of an asset and the little deposit that they are expected to pay to this company to acquire this asset. So that if someone wants to acquire a tuk-tuk that ordinarily would be 450,000 from this company X, then they only need to pay a deposit of 70,000.
Yes.
And how we will look at it is that I only need to cough 70,000 from my pocket, and the rest of 38 weeks, which is a surplus of 3 years, about 2 months.
Yeah.
Then I should be paying 6,000 per week. Not 38 weeks, 38 months. Yeah, I should be paying about 6,000 per week.
Per week, yeah.
Then that challenge is that the excitement of paying this 6,000, because they normally understand they raise more than that 6,000 in a week. Then they run to it. They don't even read the contract. They sign everything. And let me tell you that companies write the terms in very fine and tiny font.
Yes.
And they are normally so detailed that if anyone in his logical mind, without the pressure of making money or the pressure of acquiring something, would read through the whole document, they would not take it. Most companies, you would not take the facility. The asset finance facility, most people will not take it because you will always find an unfair clause in the contract. In the moment you sign, you commit yourself to it. Now, by the time this starts to bite you, normally it bites you in the penalties, because if you default, there's a penalty clause for it.
Okay.
Remember, default will arise into the company hiring an auctioneer who will come to repossess the asset, the vehicle, the tuk-tuk, or the boda-boda. That repossession has an expense that will now be attached to your arrears. Remember, there's an arrears, and then on top of these arrears,
Yes.
there is now a repossession or a recollection
Yes.
fee that is being charged by this auctioneer, which should bear entirely. And then there is also penalty for that default.
Yeah.
So by the time you are releasing, they're releasing back your asset back to you. In your assessment, you may have paid even 3 times your actual monthly disbursement for this loan, but you have not paid any monthly disbursement. You have paid the arrears and the repossession fees for this auctioneer and the penalties for the delay of payment of that arrears. So whatever now falls due is actually the next one, next installment. So you've coughed almost 70 or 100,000, but you still have 25 to pay within 2 days or 3 days. Then now you are in a complete fix of finances because
Yes.
you cannot also not pay the next installment. So they are also going to repossess you in the next installment. That is the disadvantage we have. My view is that a rightfully thinking Kenyan, if you get a contract and you feel that you don't really understand it, maybe you get some services of a legal mind to also help you, take you through the contract, so that when you are getting into it, you know exactly, and take your time to understand the contract. Some of us walk into banks and what we look at is we are going to be given 75% of what we want,
Yes.
and I need to only look for 30% or 25%. That excitement of the 75%, I just sign documents without reading. Let's just read.
And once you've committed, it is now this law is going to abide you.
It is going to abide.
And this is now where the problem will start.
Yes.
Now, for instance, if someone has now, there's something that we're talking about, I don't know, that it is in the school of law, that if the tuk-tuk was to cost 450,000,
Yes.
but you've paid up to 2 million,
Yes.
because now there are this, you didn't pay, it was repossessed, there's this fine, so many things.
Yeah.
So can someone lodge a claim, not only in a small claim court, but in any other division, to claim that I paid much, way much than what the actual price
Yeah.
would be?
I think that if you go by what the contract said and you have looked at what your contract you ought to have paid on a monthly or on a weekly basis.
Yes.
And your assessment is that my computation says that by now I should have paid, by my paying 1.3 million,
Yes.
then I should have completed the payment for this entire asset. Then, and you compute and you realize that there is an excess that cannot be explained.
Yes.
Because my question to people is, at what point do you discover that you have been paying an excess? When did the excess start? Why were you even paying this excess in the first place? Because if you know that you are paying an excess and
Yes.
this excess started on this day, then I feel that it is you actually slept on it. Yeah. But the moment you wake up and discover that, wait, I have been paying, because some of them are also, and let me tell you the truth why people don't realize that they are paying an excess. The actual loan document sometimes gets revised at the request of this customer many times. And I'm not speaking from a finance person perspective. I have no idea how finance works. I'm speaking as a lawyer who has seen that this loan probably was restructured 2 times during its payment. Now, with the restructuring, sometimes new terms come in, including the extrapolation of the time for completion. So that if then you had paid 38 months and you are to pay them within 48, or you have paid 30 months and you are to finish in 36, sometimes restructuring means that the amount you pay per month should reduce.
Yeah.
Now, and then with its reduction, the frame of time is expanded.
Yes.
Sometimes if you don't compute it quite well, you will discover that you are still going to pay more. Yeah, but most people, because they want the burden of paying reduced on their shoulders, then they accept, and then before you know it, you are paying beyond the time you ought to have paid. Sometimes it happens with the repossession. When the vehicle or the bike or the tuk-tuk is repossessed, then the concern becomes, are you having difficulties in paying? Are you not able to keep up with these installments so that we can restructure it for you? Now, sometimes when they restructure it for you, I don't know how it happens, but it happens to be that what you are supposed to then pay appears to be more than what was remaining as a balance. And then now you end up paying an excess. That is from what I have seen in documents people come with after they have felt that they're paying way too much. Yeah.
So what is important is before someone goes and purchases something, that person should seek an legal mind advice.
You can seek legal advice, but you can also make sure you understand it from that financier's perspective.
Some cannot understand.
Because if you want to understand it from your perspective,
yes,
the challenge will be that when the time for repossession comes is when you will now understand. So get to understand it as if they are repossessing it tomorrow. Try to behave as if tomorrow I will not be able. When we get these assets, sometimes someone has an employment. Sometimes someone has a very stable business that he knows that 6,000 will not be a problem to raise.
Yes.
Someone has driven someone's tuk-tuk and assessed by himself that I normally make 10,000 out of this person's tuk-tuk. So let me go and take mine. So they are comfortable, but they don't look at it in the sense that maybe tomorrow I will fall sick. And if I fall sick, I will not be able to pay for 2 weeks or 3 weeks. Then they will repossess it. So I want to understand it. Start understanding it from that point.
Yes.
Ask the banker or the microfinance, that what happens if I don't pay within 2 weeks. Let them break it down to you from their perspective.
Okay.
And even take notes. Even record it on your phone, so that you have a clear understanding of how the circumstances will be if you default. We are in Kenya. Economy is tough, and it's a possibility that you will default.
Yeah. And because also we don't know what is going to happen tomorrow.
Exactly.
Though the financial people tell you that don't budget with calamities.
No, you have to. Lawyers will tell you to budget with calamities.
Okay, we are winding up, and I'm very grateful that the insights in this episode is going to create a very good picture for most of the Kenyans.
Yes.
I remember we were just discussing all that the small claim court, the corridor of justice has bring to ensure that as much as we are trying tutafuta huku na pale, tukipambana na either one term ama two term, tuwe tuko hapo katikati, tuelewe mambo ambayo yanatuhusisha kama Wakenya na kama jamii. Nataka tumalizie na ukitoa wasia wako wa mwisho kwamba je, unahisi kwamba mahakama hii imekuja kunusuru wafanyabiashara wadogo au imekuja kunusuru kupunguza mrunduko wa kesi katika mahakama zetu?
Yes, it is true that imekuja kupunguza that one that you are calling mrunduko
ndio
ya kesi katika mahakama zetu. And I'll give you an example of when people started filing personal injuries claims kwa small claims court. It became a big relief for the magistrates. saying that finally we have a lesser amount of work to deal with as opposed to what we used to deal with in terms of what we call running down matters, personal injury claims. Again, right now, when they have ordered that those needs to go back to the magistrate's court, again, the pressure of the amount of matters is also still being felt in the magistrate's court. So I believe that the intention initially ilikuwa ni kupunguza that pressure.
Yes.
I also believe that it is actually quite effective because of the timelines. The timelines are so strict that matters must be concluded in 60 days. And to be honest, the backlog period, according to court, I think courts is after 2 years of filing of the case. And there is no possibility that you will find a small claims court matter go beyond that time. So in terms of reducing backlog, it is a big plus for the small claims court.
Wow.
The first question was in terms of
Sio tu mrunduko na je itafanikisha
for the general population.
Yes.
Has it really helped to aid business? I will say yes, and I will also say no. I will say yes in the sense that yes, it has been very easy for us to lodge, file, and get orders. But I will say only 50% we have been able to fully recover in terms of now the full payment post-judgment. We as consumers of the small claims court, and I say this as an advocate who acts for parties in that court, have a little bit of struggle with the post-judgment proceedings of the small claims court, in the sense that it has become now another problem. That after the judgment, I hope that the reintroduction of detention and committal to civil jail will fix this problem. But now the problem for us was that it becomes so hard to now fulfill the fruits of your client's litigation by recovering the full amount, attaching property, selling the property. It's been quite problematic. But we have managed, especially for those that come to court within 2 weeks and admitting that they actually owe the claim and starting to pay immediately. That has been quite fruitful. So it's a yes, and it's also a work in progress for the remaining 50%.
Yeah. What could be what can now the judicial system adjust to ensure that this thing flows smoothly?
I don't see any. The other challenge is that the appeal process is not so time bound. In fact, one of the amendments is to actually bind the appellate process.
Oh, you can appeal in a small claim court?
Yes, to the High Court, and it only ends there. Now, the challenge is that it is now being, in the new amendments, we are expanding the time for appeal to 12 months, which for me would not make sense for a matter that you said must be concluded in 60 days. Then now the appeal should take
12 months.
Yeah, 365 days. Kidogo is too much. So that again comes back to the question of the time, so that I only need to appeal and then I drag it for a whole year. So that is another challenge. So that if post-judgment, if they appeal, again, we are now locked in time.
Okay, but so this means the petitioner and the defendant can decide not to pay and use the dilly-dallying process of appealing for these 360 days.
Yeah. You can take him to court and succeed. But then he can appeal.
Yes. And
then now, in the High Court, now it's a different playing field, because
there is no 60
until
days.
the new act is amended, then the timeline for the High Courts will now be substantial. As we speak, then it can take as long as...
Ni kama kawaida. Asante sana wakili. Imekuwa nzuri. Jina langu ni David Otieno na hii ni The Legal Mind. Nimekuwa na Conrad. You know that name pronouncing it?
Conrad. You have to relax your tongue.
Ni kama naongea Kikamba Kindongo. Wakili Conrad Atiang amekuwa nasi hapa kujadili masuala mazima kuhusu mahakama ya madai madogo madogo. Kwa hivyo tutazidi kurudi tena tuweze kufahamu mengi kuhusu mahakama hiyo. Kuna pendekezo katika mswada ambao umeletwa. Mswada huo una mapendekezo kadha, hatungeweza kuyajadili leo, lakini siku nyingine nitayaleta hapa wakili tuweze kujadili na tujue mbivu na mbichi.